and the person far away can say, no, I can't really do this, have the successor act. But I would tend to default towards someone local as the first choice for power of attorney because they're here. Yeah. Make sense?
Fine.
Yeah.
Could you have 3 or 4 successors?
Absolutely.
Yeah.
Yeah, you can name all kinds of success.
One at a time.
Yep.
It's not this person and the next one.
Mhm. Go ahead.
Was creator who could say, she does the work, and this person would not actually get involved in power of attorney stuff, but they have to, say so.
What I tend to recommend is you name one person, you set out your wishes, right? And there's room in these statutory powers of attorney to say, I don't want these things to happen, or I want these things to happen. And one of the things that I have done in the past is say, like, if you have for parents of young adults to say, I'm naming someone more my age, I want them to consult with my child every step of the way. But somebody has to have the decision maker, and the hospitals in particular are going to want to look to one person to say, okay, this is a decision.
Would you recommend doing like a medical POA and like a financial POA?
Yes, yeah, there are 2 different types. And so, and we'll talk about each one of them in more detail, if that's okay. Can I put down? Okay. So when you're doing this, when you're naming agents, you also want to think through family dynamics. Because, oh boy, let me just say that I have seen all kinds of ugly family dynamics come out when mom or dad, the glue that was holding everything together, is incapacitated or has died. And it, you need to think some of that through. Would this work well? Would these siblings respect that sibling's decision? Or should I get somebody, a brother or a sister or someone else? And the other thing that people don't do is talk about preferences with your agent. And this is an area where you can really help your agent when it comes time for them to make decisions. When you're talking through scenarios, if you're kind of flying blind as an agent, the person will love them. Geez, I think that's what she would want, but I don't know. That's a lot of extra weight. If you've already had a conversation, the principal and agent together had a conversation, it's much easier for agent to say, I talked to principal and this is what we talked about. And that can help, kind of the crisis, help deal with the crisis. Parents of college age children should ask their children to give them powers of attorney for both healthcare and property, because when they turn 18, you have no right to any information from their college, from their doctors, or anything like that. And having the ability to call a hospital and get information as you're rushing to a child's side is really, really important. So powers of attorney for healthcare allow agents to make healthcare decisions for you when you are unable to. Doctors will obviously go to you first and try to figure out what the best decision is. But if you are incapacitated, if you are too drugged up, if you are unconscious because of a surgery or something like that, they want to know who is going to make the decision. And the powers of attorney for property allow agents to make financial decisions for you. Living wills are a little bit different. They direct healthcare providers to provide only comfort care in certain situations. And we'll go into that in a little bit more detail, and we'll see how these all kind of pull together, but there are places where there are little bits of gaps.
Your recommendation is for everybody to have all 3, correct?
If your wish is comfort care only at the end of life, yes. If your wish is not comfort care at the end of life, but you want to stay alive at all costs, then you don't need to living will. Okay,
Do people use an institution like Private Trust for healthcare power of attorney? I mean, is that done?
that is not done. Most financial institutions will not act as a healthcare agent. Yeah. Most financial
Property, yeah.
yes, they will take that role and they will typically fund a trust, because there's typically a trust involved. They, making kind of live decisions is not something that financial institutions are super comfortable with. There are professional guardians that I believe will take on that role for someone who has no family, no friends. And one of the purposes of a healthcare power of attorney, two together, is to avoid the need for a guardianship. So if you're not capable of making decisions, the state has a mechanism for someone to make decisions for you. And that involves someone petitioning to become the guardian of the person to make healthcare decisions and the guardian of the estate to make property decisions. And that requires approval from a judge, both of the guardian and also a number of decisions that someone would make. So it's very unwieldy, it's very expensive. And that is something you want to avoid pretty much at all costs. It's just, it gets very, very messy. So let's focus a little bit on the healthcare powers. Your agent will have the authority to accept, withdraw, or decline treatment for any physical or mental condition, including life and death decisions. Very broad, right? They can admit you or discharge you from any hospital, nursing home, other institution, including a mental health facility. They can access your medical and mental health records and dispose of your body or remains, including organ, tissue, or whole body donation, autopsy, cremation, or burial. So very broad scope. And that little piece of disposing of remains is the one piece where an agent can act after you die. Yeah.
In practice, are whole body donations readily accepted by institutions of old people
Well,
who've died, obviously?
yes. I can tell you that my mother-in-law died a few months ago, and she had donated her body to science. And I can't remember the name of the organization, but they come and they take the body, and 2 years later, you get whatever cremated remains are left. But yes, they will do that, and they want to. She did it because she had dementia, and she was a physician, and she knew that the ability to study the brain would be a helpful thing. And physician till the end, she arranged for the donation of her body prior to her deepening incapacity. So in the power of attorney, in the statutory form for healthcare, you select when your agent's authority becomes effective. The most common choice is when you're unable to make decisions, but you grant current authority to access medical records and get a medical opinion that the principal is unable to make decisions. There are two other options. One is to make it effective only when a treating doctor determines you're unable to make decisions, which means your agent can't go to the treating doctor and say, hey, are they unable to make decisions? And can I see the medical records about that? The third option is make it effective right now, but retain the right to make your own decisions. And like I said, doctors and hospitals are going to default to you if you are capable of speaking, asserting what your decisions are. So of those three, you can select which is your choice. And then there's also a statement that best expresses your wishes on what's more important, quality of life or staying alive no matter how sick you are. You can include limitations, additional descriptions of what you would want. Directions that any living will supersedes the powers granted to an agent with respect to comfort care at end of life. So it is, it's a statutory form, but it is, you can kind of customize it to what you're looking for. I will say medical crises and end of life, and I'm sure a number of people in this room can attest, are usually stressful. They can be a marathon, and your agent is being called on to make very difficult decisions, usually in a very compressed time frame. So, like I mentioned earlier, help them by having conversations with them about what you would want in different scenarios. You've gone into cardiac arrest during surgery, but the surgeon thinks that they can, revive you, finish the surgery, and you will fully recover. Would you want to do not resuscitate order in that position, or would you want go ahead and resuscitate?
Go ahead with what was you said, or would you want, go ahead and.
Oh, would you want to go ahead and resuscitate?
Oh,
Or would you want to do not resuscitate in that situation? So if your agent knows, the more they know about those kind of scenarios, the better they can understand your approach to things and make decisions that might not match that exact scenario, but are similar enough that you're giving guidance to your agent. And then, that ties into the second point on the slide, that people really do often start out saying, oh, no, don't resuscitate. And then when you start to have conversations about situations where you might want resuscitation, they say, oh, well, wait a minute, I want something a little more nuanced than just a straight DNR. So again, these are, and the hard thing about this is you're talking your own end of life, right? And the two things we all like to avoid is death and taxes. And what do estate planners deal in? Death and taxes. And so we make you, we have uncomfortable conversations with people and, have you thinking about things that can be very disquieting. There's no right answer. There's no one answer. Everybody has different views on all of this, right? So it's really kind of getting comfortable in your own mind and then putting on paper what best reflects your thinking at this point. Yeah.
Do you want to mention the post agreement?
I was gonna get to that. Let me do living will first.
Sure.
So living wills apply only if you have, and this is the language in the living will, an incurable and irreversible injury, disease, or illness judged by your attending physician to be a terminal condition with death imminent, except for death delaying procedures. So the death delaying procedures would be like artificial nutrition and hydration. And so that's pretty narrow because it has to be a terminal condition and death is imminent, except for those death delaying procedures. So that covers a very narrow strip, and the power of attorney for healthcare covers a much broader strip, which is why if you want a living will, I think you also want a power of attorney for healthcare. The living will would direct that you be allowed to die naturally with only the administration of medication, sustenance, or the performance of any medical procedure necessary for comfort care. Typically, that might mean morphine. It might mean, an oxygen cannula, maybe, depending on situation. But, a lot of comfort care at very near end of life really is pain relief and bringing down anxiety and eliminating pain. The living will also does not direct the withdrawal of sustenance. Now, an agent under a healthcare power can do that, but the living will doesn't. Our living will statute predates the powers of attorney statutes that have been updated a number of times. I don't know why the living statute hasn't been updated, but it hasn't. So you're kind of weaving these together to create you know, authority to deal with everything that you might, your family might need to deal with at the end of your life. Jeff mentioned HOLSTs. HOLSTs are practitioner orders for life-sustaining treatment. And you select your choice for treatment if you're in cardiac arrest. And that also can include additional instructions on nutrition and hydration. A lot of hospitals want a HOLST. A lot of nursing homes want a HOLST. A lot of assisted living facilities want a HOLST because they want to know what your choices are on those things. And that's a form that they're very familiar with. It's also signed by both the patient and the doctor, and it goes into your medical records. I think probably everyone in the room has heard of a DNR, resuscitate order. That only covers resuscitation in cardiac arrest. HOLST is a little broader than a DNR. And I remember when my mother was having emergency surgery, they asked her if she wanted to, change a HOLST to put in resuscitate during surgery, which she did, and then she changed it back after the surgery. Yeah, go ahead.
You have a post, you have to have the principal and the doctor sign the document. What if the doctor retires and is no longer on the planet and the document has his name on it?
I think it's still part of your medical records.
It's still
I think so.
the hospital or the nursing home in most instances
I
accept.
think so. I mean, I think a better practice would be to sign another one if the person still has capacity and is able to do it. But, some of these things, it happens. You do documents and 10 years later, there's an event, you're incapacitated. You can't change the documents. So, they stay in effect. So, powers of attorney done 10, 20, 30 years ago in Illinois are still valid today. The form's been updated, people are gonna be less familiar with them, but it doesn't make them invalid. And I think the same would be true with a post. Okay, property powers of attorney. So this is a companion to the healthcare power of attorney, and it allows your agent to make financial decisions for you, either concurrently with you or when you cannot act. The intent of the statute is to mirror the power that the principal has to do anything. There are some gaps. You can limit the category or the powers either by category or by specific rules. So you could say, my agent can do everything except, transact business with this particular account, or can do everything except change beneficiary designations. Like you can't mess with my estate plan. And you can also add powers to fill in gaps. So one of the things that the statute does not allow on its own is the power of an agent to make gifts for the principal, and particularly to make gifts to the agent, him or herself. And a lot of times people have children, natural objects of your bounty, acting as an agent. And, you get to end of life and somebody realizes, oh boy, mom or dad is pretty close to a taxable estate. We should give away some money. Well, if the power of attorney doesn't authorize it, technically someone could go in and challenge any gifts like that. I think the reality is in a functioning family that would probably just gonna ignore that. Yeah, we did that. But to dot your I's and cross your T's, you want to make sure that if you intend for your agent to be able to make gifts or to take property out of an account and add it to your revocable trust, that's expressly included in your power of attorney for property. Let's see, there was something that crossed my mind there for a minute, about those gaps. Oh, okay, so the power, so if an agent makes a gift to themselves, technically that's self-dealing, right? You're acting with somebody else's money and you're enriching yourself. So that would be a breach of fiduciary duty. And that's why the statute doesn't allow it. Some states do, but Illinois does not. So that's why, a lot of times, what I did in private practice is clients wanted the ability to make, like, for example, annual exclusion gifts to all of their children, including a child who was named as an agent. So I would include language for that purpose.
So if I have a POA for property, or for that matter, for health, and I've used the statutory forms provided by the state of Illinois, and I moved to Nebraska,
They're still valid.
there's still in any state in the union.
They are, but you're really much better off re-executing new powers of attorney. Again, if there's capacity to do so. But if you're voluntarily moving to a new state, I always recommend that people find a local estate planning attorney, redo your plan. To make sure that at a minimum, the powers of attorney are forms that the financial agent, financial houses and the hospitals and doctors are used to seeing. Because the other piece of that, if it's an unusual form, if you've drafted your own, you can draft your own, we don't have to use statutory form. That will add a layer of review, because a doctor or a banker is gonna look at this and say, I don't know this form, I'm sending it to my legal department. My legal department has to pick it up, review it, look at the statute, make sure that it complies with the boundaries of the statute, if it's your own created form. Or look at the other state statute and say, is it valid under that state law? Yes, it is, therefore it's valid. We can validly rely on it. So it just adds more complexity to the process. And that's a time when you really want to take out complexity, when someone is relying on a power of attorney, because typically that means there's very likely a medical crisis going on at a minimum. There's a longer term financial issue that someone's taking care of. Yeah.
So say there's an incident
Mhm.
and health incidents, and so the agent needs to step in. How does the hospital get the POA, the document, telling them who's to be doing this?
So they can get it in a couple ways. If you are going in for elective surgery, they often ask you, do you have powers of attorney? Can you provide us copies? If you have been, say, in an accident and you are incapacitated, usually a family member has the power of attorney, because most people say, you're my agent, here's my power of attorney if you need it.
So the agents should probably have copies of the
Yes.
Sometimes you might want to keep it on the cloud.
Yeah.
I have clients that were trying to encourage them to basically do this for their college children. And one was an 18, client was in Washington, DC, child was in Florida, got a huge accident, concussion, like serious.
Yeah.
And he had it, but he could pull it off the cloud and get it to the hospital, so he had access and they were talking.
Yeah, I have it in the cloud for myself.
But a lot of times people sign the documents and it sits in the safety deposit box for 10 years. Oh, where is it?
Right.
But what you do. And if you know you're approaching meeting them or the person you're an agent for, go to the safety deposit box or wherever it is, take a picture of it, keep it on your phone. It's either under memos or that, because that's at least you're sitting there in the ER or at the hospital bed. And Northwestern says for the 6th time in 4 months, do you have some power of attorney? Like, yes, you fill one out every time we come in. But if you have one on your phone, it's like, here it is.
And then they take that.
Yeah.
Yep.
Cool.
Yep.
I mean, they prefer something,
Yeah, piece of paper.
but how many of those do you carry on in your pocket when you go out to walk? You just don't. As I say, most of my stuff's in the safety deposit box.
Yeah.
That's not very useful on a Saturday at 4 PM when the bank doesn't open until Tuesday because it's Labor Day weekend.
Correct.
Yes, 4th of July.
Yeah, and the cloud can be very, very helpful. I'll just sign on More fun, very helpful. Now, the other thing that Illinois has, and part of these things go with, if someone is ill, and they are unable to act, Illinois actually has a statutory scheme of a preference of people who can make healthcare decisions for that person. You don't really want to have to rely on it, but there's kind of a fail-safe under Illinois law. And I don't know about all of you, but my experience with hospitals, if you are there saying, I'm the spouse, daughter, whatever of the patient, they answer any question you have. But it's the decision-making part that gets a little trickier, particularly if it really is end of life, because the hospital doesn't want to say, well, she said she was her daughter and said, go ahead and pull the plug. Oh, whoops, we shouldn't have done that. That'd be a very bad result.
Does clergy ever get involved in any of these aspects that you've been discussing?
Clergy.
I'm medical power of attorney for several people, and most of them have younger kids than you would in your youth group. It was like, we want you to be medical power of attorney over curriculum terms X number of years old. And that's been, can I just make a quick plug for when you're sitting down with the people who are your medical power of attorney? Man, be specific. Think of all the things that could possibly happen and be real clear. Like, yes, I want this. No, I don't. Well, I guess I sort of like that. The muddying of waters is what you don't want. Why you're doing this, it's going to be that clear. Like, yep, in this box, we do this. Not in the box, we're not doing that, right? With a couple of folks that have those like a follow-up conversation like a week later, like, I was thinking about what about this, and this? And they've had to revise some of the documentation. Oh, yeah, right. So be trying to think of all the things, but also know that you can update these. Really, it's not monumentally difficult to update them, right? Change them. And if you have a change of heart, I'm sure you can say this is the one, but if like today you're like, you know what, I don't want to be revived. 6 weeks from now, you're like, please do not let me die, revive me, right? Like you want to make sure that it's got think about this, that it's never a one and done. You want to make sure that what you're thinking, if you have a change of heart of these to update these so that it accurately represents what you feel you want in the moment.
Aren't there only two options? Revive or not revive?
Well, yes, but I mean, it's just
But there's a gray area.
right.
Which has shades of gray.
Right.
Some situations do, other situations don't.
Right, but revive me if you think I can still be a good living person, but if I'm brain dead, don't.
Right, exactly.
So again, it's and the other thing is, if you know you're towards the end of life, or if you, let's say, expect because you're 90 something and you're failing, you have your DNR form on your refrigerator. And you have your healthcare power of attorney on your refrigerator. And I've been there, done that. I had to call the fire department or the police, and then they sent the fire department to say that my dad had died. And they raced in with all their equipment. I said, don't come with the sirens and the lights. There's no need, And they said, we have to go see if we can revive him. And I said, no, it's not, trust me, not revivable. But I had the form on the refrigerator door so that they would not go break his ribs. And then they went back and said, you're right.
But
if you don't have that, do they come in?
Oh, yeah, they will revive.
Yes.
Absolutely.
The default is
To piggyback, and I'll get you in a second, to piggyback on what Matthew was saying, do what is right in the moment, right? Things can be updated, things can be changed. Your situation changes. You should be thinking about this with some, but if you don't make a decision, the decision is made for you, right? If you don't do a power of attorney and a living will and holds, for example, you could have a massive stroke, have your heart stop as a result of it, and be revived, and be in a bed, and not conscious and not living what you would define as life. So do these things, and then refine them and tweak them as you go. Because as Matthew said, they're not complicated to update. But at least get your basic thoughts down.
And it's not as hard to have some of these conversations as you think. I mean,
Yeah.
it's hard, it's hard with someone's 55 or 65, like, okay, so, but if someone's towards the end of life, my dad would say,
Just thinking about it
whatever
already.
you do, this, that, or the other thing. Or, for weeks, months, he'd say, I've had such a wonderful life, I have no regrets. I just have been so lucky, and I'm ready for the good Lord to take me. So when that happens, don't be sad. Now, this went on for a year and a half. But he every day was grateful. Every day I could hear him say his prayer through the door, because we lived, doorway right in our house. And then when he finally went to his house, I was in the room next door. And every day when I, say goodnight to him, he said, I'm ready for the angels to come get me.
Yep.
And then I say, Dad, you gotta drink water, because you can't stop eating and stop drinking. And do this, and I said, when the angels come to get you from some night, you gotta be able to flap your wings and help them. Just, so you drink water, you have to do something, because you don't want to put all the work on the angels.
Other thing it's like, it's as someone who's a younger person who has older parents.
Yep.
I have been so thankful that my parents have let me know what they want. Because as your kids don't want to screw this one up, right? This is like the big decision. And if they know what you want, they'll be so thankful that they knew what the heck you wanted. So don't let your squinginess about talking about when you die get in the way of them knowing. Because the peace of mind of knowing what you want is worth its weight in gold for them.
Yeah. Well, and I will say, my dad, when he died, he had multiple strokes, first the left side, then the right side, and he was very, very clear. He just looked at me and he said, it's time, I'm gonna go into hospice. And I said, well, it might not be quite as easy as you think. He said, no, I'm just gonna stop eating and drinking. And he did. He lasted about 3 weeks in hospice. I think he had little bits of water earlier, kind of early in the process, and then just it was a very peaceful end. Yeah.
Well, I think it's also important to pick someone who can make the time for you. I have a much smarter, more capable brothers, plural. One of them's a doctor. He was 20 years ago, the first
Yeah.
It was my mom, then Robert, because he's the doctor.
Yep.
And can make the intelligent decisions. And then it was me and then the older brother who didn't live nearby. But it became clear that I was the one who had talked to Dad for the last 10 or 15 years. Not that Robert didn't. And my parents also knew that I would consult with my brothers if I could find them,
Right.
And to do anything, whereas the others just didn't have the time or couldn't make the time, or it wasn't a priority to sit there and listen for 3 hours every day about, this, that, and the other thing.
Yeah.
But it's important to have that person who may not be the smartest and brightest, case in point, but at least has the time to commit to listen to what she wants.
Yeah, that's hugely important. Yeah.
Just a quick tip to add to what Carrie's saying. A lot of people don't want to put those, like a DNO fridge. If you put those papers in a Ziploc bag in the freezer,
Yeah, that works too.
the EMTs know to look there.
No.
I had numerous, emergency people tell me, oh, if they're in the freezer, we'll find them. And so, yeah, and of course, in the Ziploc bag, they don't get spoiled. But you don't have to look at it every day.
I would also encourage you all too, if anybody here has children, I would encourage you to encourage children to start thinking about some of this and start processing and thinking about it too. Because I've absolutely seen it where, grandma or grandpa had all of their documentation taken care of, but 24-year-old so-and-so gets into an accident and never thought because they were in their 20s, right? So you're never too young at the same time.
Yeah, I had a family that, as each grandchild turned 18, they sent them in to do their estate plan. And it was very simple, and it was usually I leave everything to my siblings, you know, but there was a power of attorney, and there was for healthcare, there was a power of attorney for property. And they had a will, they had a revocable trust. So it is, TJ is absolutely right. It is never too early to start having conversations. And the intergenerational conversations are super important. Super important.
And I had a friend who, their kids went off to college and they didn't have a power of attorney.
Right.
And they were in an accident, like you said, and they called the hospital. Because a friend had called and said they were in, and the hospital will give you the information. I'm their parent, I'm your mom.
Yeah.
And they go, over 18.
All right,
Over 18, too bad.
Yeah.
Can't even get the credit.
Yeah, I think, yeah, when they turn 18.
Yeah. Very important. Or before you send kids off to, or grandkids off to college. Yeah, the power, at least the powers of attorney.
Yes.
So for the financial power of attorney, another very important consideration is your agent's financial acumen in light of the complexity of your financial situation. Sometimes family members make sense. Sometimes financial institutions make much better sense. And most, I think I started this earlier, most financial institutions will act as an agent for property. And the agent may individually and end up taking individually owned property and transferring it to a living trust to make it easier to administer. And that's actually what it's, I suggest people do while they're on competent. But, you know, I've seen situations where, well, we're gonna pick the oldest child because, you know, we're going primogeniture order to be an agent for financial matters, and the oldest child is a disaster for financial matters, but their, you know, their baby is, you know, an accountant. Okay. So think about financial acumen, think about the complexity of what you, whether it makes sense for it to be an immediate family member, an extended family member, you know, a professional advisor, or a financial institution.
I don't think the syllabus that might want to talk about what happens when someone dies at that state, probate process and the costs associated with it.
Yeah.
Risks of dying.
Yeah, absolutely. So, and that's a little more for next week, but
Sorry.
no, totally fine. Just as a quick overview, if you don't have a will, the state of Illinois has one for you. It may not be the people that you intended it to be. It's half to spouse and half to children, if you are married with children. Which particularly with young children can be a disaster because that requires a guardianship for the young children. And the spouse only has access to half the assets to support the children. Probate, it is time consuming. It can take weeks to get access to a judge to get an order appointing, and then what are called letters of office that tell everyone you have the authority to act as an executor. And in that case, it would be authority to act as an administrator. And it's expensive.
Is that the judge? Or
No, it's actually a court issued, it's called letters of office. And it's court issued, it has a seal on it, and it says, it tells the world this person can act with respect to this. So again, like avoiding guardianship, you know, unless you have a reason to have a probate estate, it is often much easier, more streamlined, less expensive, to avoid a probate estate at death. Yeah.
Next week, will you be going into like the differences between revocable and irrevocable trusts as well? Okay.
Yep. Yeah. Yeah. Next week we'll go over, you know, kind of the key documents in a basic estate plan, touch a little bit on more complicated matters. And those are, you know, some of the irrevocable trusts that you would create during your lifetime. And you know, talk about wills and trusts and kind of how all this ties together. And that is for next week. So does anybody have questions?
So you mentioned a couple of times about, you know, if you have an epiphany about, you know, you've changed your mind on something. making sure you update the powers of attorneys and living wills. Is there a rule of thumb for how often or when you should be reviewing these things if you have them in place already?
Yeah. My recommendation is any major life event. Marriage, divorce, birth, death, in the immediate family. So it could be, a parent of, your parent has died, you've come into more money, and it's held in trust for you. That's time for you to look at the rest of your estate plan and say, does this all continue to make sense? Now that this is coming, do I want to increase a charitable gift that I have? Do I want to, change who the executor or trustee is? So major life events are always a good time to review all that. And then generally, I used to tell clients, every 5 years, just kind of take a look at it. You don't necessarily have to go sit with your lawyer and go over it, but take a look at it. Does it still make sense? Have you moved cross country? Did you name your good friend who is no longer your friend to act in a capacity? Did you say, oh my goodness, my kids are way too immature to do this, and 5 years later they're young adults and think they're capable of handling certain things. So I think just kind of a cadence and just kind of getting used to it. Actually, kind of a good time to do it is at year end, right? Because the holidays are here, you're looking at a new year, right? People make New Year's resolutions. And being able to just sit down, either on your own or with a spouse or partner, saying, hey, let's take a look at this. Do these people still make sense? Have circumstances changed? Is there a child who you were concerned they were never going to find their way in the world, and now they found a way? Is there a child who has become disabled? Because you can become disabled at any point in life. Do you have, other extenuating circumstances that would make sense to change your plan? And, plenty of times people do the review and they say, yeah, no, this is all still good. But it also just it's the refresher. So that, once you've kind of gone through it again, you can say, yeah, makes sense, or no, we need to change a few things. Yeah.
Would you make these slides available for reference? Refreshment?
Of course. The holiday weekend, it's a bit of an interference because I didn't finish these until yesterday. Yeah.
And if anybody wants a digital copy, feel free to email me and I can send you a copy on email too. TJ@christchurchwinnetka.org.
One of the things I've seen people. Take someone and say, Timmy, I know you've heard the trustee for things, but because of all the things, you know what they are, Timmy, we're not one of the right? Having the conversation first was the hardest one.
Yeah.
After that, it becomes so much easier. And I've been in the room when parents and grandparents have sat down and said, okay, here's what we're going to do. And what I've almost across the board universally seen is that the first couple of paragraphs of text harden. But like anything else, it gets a little bit easier. And then some wonderful conversation has happened. And people have had some of the best, most meaningful conversations. Like they hadn't had a good conversation with kids for 20 years. And now they're having this really deep, wonderful thing. It's been very life-giving, actually, for people to know what the world you want, or who's in charge of what and why. It's not as hard as you think. That's what I'm trying to say. It's like once the snowball gets rolling down the mountain, it does pick up speed and and it grows in awesome. But don't let that stop it.
Yeah, I have a question about attorneys. We have an attorney that prepared our wills. That I would presume is a estate planning attorney. I mean, that's questions that would be dig deeper. I mean, he will help us prepare it for us. So he must be an estate planning attorney.
Not necessarily. I mean, there are people that,
That just take it on.
yeah, that, kind of do a general practice and they would take it on. I would say the more sophisticated your financial situation is, the more wealth you have, the more you wanna go to someone who is a dedicated estate planning attorney, because that's, and I haven't talked about any of this yet, but the tax laws that underlie a lot of the planning that people do change all the time. And it's really hard if you're dabbling in that to stay on top of it enough to continue to be competent. Simple will, simple trusts, when people don't have tax planning that they need to do, that, you know, that's a different story, but there are, you know, there are a number of ways to find good estate planners. And TJ mentioned the American College of Trust and Estates Council. I'm a fellow in the American College of Trust and Estates Council. Those are people who all they do is estate planning. And they do a lot of education about estate planning. And there's an online directory, and you can find probably 50 or 60 of them in the Chicagoland area. And as a rule, the experience that I've had with other fellows has been excellent. They're good lawyers.
What's the term, I mean, what's the prefix again to that?
It's ACTEC, ACTEC. It's the American College of Trust and Estates.
ACTEC.
ACTEC.
Oh, nice.
Yes.
I think you wanna also, this was my experience. But you wanna make sure that the person that you've engaged to do your plan is the person that's doing the documents.
Yes.
Sometimes this is
Right.
sometimes you can basically get the front guy
Yep.
and he's basically
Oh, yeah.
some subordinates write all
Yep.
the documents and then he might review at the end.
Yep.
And I think that creates some credibility gaps in some levels that you should just be cognizant of.
Yeah,
Doesn't say it's not gonna work out, but
Yep.
there's a
He may not be the point guy.
Yep.
Two quite different questions. One is, are there any discussions about a change in law that are imminent? Congress is considering increasing an exemption. Yeah. So, okay.
Preparing impact legislation right now.
And the second question, what if your attorney herself is aging?
That is an issue. It's an issue.
If you're not old.
They do,
Yeah.
they do, and they're retired.
After they should.
Too. You know, I would have a conversation and say, you know, what are your succession plans? And if you're not comfortable with the succession plans, find a younger attorney.
Yeah, I've been told that you should have a doctor and an attorney that's younger than
Yes.
you.
Yeah.
and also
Yeah.
trusteeship,
Yeah.
which would avoid and mitigate that risk.
Correct. Yeah, corporate trusteeship is actually a really good, I mean, people say, oh, it's so expensive, but you have a corporate trustee, this is all they do, you know, for that part of the business. They have policies and procedures in place so that there's, you know, the right people looking at questions and making the right decisions. And, you know, they're handling the investments. So, yes, there's a fee. There's a lot of services that come with that. All the tax preparation work is done by the corporate trustee. So when you kind of look at it all together, it's maybe not such a bad, you know, maybe not so expensive. And in a situation where family dynamics are challenging, it is, I can't tell you how wonderful it is to have a corporate trustee who can say, well, we took your request to the committee and the committee asked for more information. You gave us more information. And, you know, we can't agree that you should take that money and, you know, put it in crypto, or whatever. So it's kind of a nice buffer. Because there is, you know, it is professional management and professional decision making. I was with corporate trustees for 10 years. The services are, I think they're very good.
And the continuity issue.
And the continuity goes away.
Aging out.
Right. Anybody else? And if you think of something else, and you know, you're here next week and you want to bring it up, bring it up.
Maybe
I would- Well, and I want to thank all of you for making this an interactive conversation. That was much more fun than me just talking about it.
And before you depart, as always, please be sure to fill in one of these participation surveys, which helps us to plan in the future. Give it to me now. Yes, if you have it filled in, just give it to me.
What's the name of the?